This is OPE review of torts. Looking at strict products liability. This is different from strict liability for dangerous activities, conditions, and animals. Now, strict products liability, the defendant must be in the business of selling the product. This is a manufacturer, distributor, retailer, service provider using the product. It's not liable under strict liability. Strict products liability and defective warnings. They must only anticipate reasonably foreseeable uses and or misuses. An example is a TV mounted on the ceiling. They should anticipate that. However, they're not obliged to include warnings for obvious dangers. An example here is the danger of standing on a ladder to clean the manufacturer's furnace, where there is nothing unique about the furnace that would add to the ordinary danger of working on a ladder. Strict products liability and manufacturing defect. If a manufacturing defect results in an accident, another party or a third party renders aid, stops and renders aid, and that third party is hurt, manufacturer may be liable because their negligence created the dangerous situation. And moving on from strict products liability to strict liability, this is abnormally dangerous and or animals, where it's strict liability in abnormally dangerous activity, where you have an assumption of risk. This is an affirmative defense, such as an employee assuming risk inherent to a job conducting safety audits of dynamite storage. It might blow up, you might get killed or hurt. Looking at strict liability and abnormally dangerous material. Here, the risk that materializes must be the same that led to the label of, quote, abnormally dangerous. And the example here is toxic material leaking from a truck, creating a puddle and causing the plaintiff to crash. There is no strict liability because the danger of the puddle is not what made the toxic material abnormally dangerous. Looking at landowners, travelers near and or next to land, you have a duty of reasonable care. You're not liable if agent acts reasonably. You're gone, you're near, and your agent is there and they act reasonably. Now, if acting reasonable, you're not liable for reckless acts of people on the land. Landowners, in the context of a slip and fall, to go to the jury, there must be evidence sufficient to show the defendant was negligent. An example here is the grocer should have known about a banana peel because of the brownish condition of the banana peel, meaning the banana peel had been there for a while. If the banana peel hadn't oxidized to such a state, meaning it was fresh, then the grocer should not have known about the banana peel. Kind of tricky or sneaky by the board. Looking at landowner and artificial condition, an example is a pond. You must have reason to know trespassers are in dangerous proximity to the condition and that they are unlikely to appreciate the risk. And here there is a duty only to exercise reasonable care to warn. Landowner, however, an attractive nuisance. Again, they must have reason to know children will trespass. So you must have reason to know trespassers will come by. Here, children for the attractive nuisance. And that children will not appreciate the danger. Look to the frequency of the trespass, any presence of signs, and brightness of the child. Criminal acts of third parties. Generally, there is no liability where harm results from criminal acts of third parties unless the defendant should have realized likelihood of crime at the time of negligence. There's foreseeability of breaking and entering after an accident in a high crime area. Delivery truck went into a ditch. It was pilfered because it's a high crime area. Misrepresentation. Negligent misrepresentation. Recovery is limited to pecuniary loss. Intentional infliction of emotional distress is not a cause in negligent misrepresentation. Looking at defamation and invited libel. There's no defamation where you have invited the libel or slander. An example would, well, in this case, libel. An example is the plaintiff investigates a case, the investigator sends a letter to the defendant, and the defendant responds, and his response letter contains libel or libelous statements. Here, the plaintiff essentially consented to the defendant's response and or publication, and therefore there is no defamation. Look at negligence per se. Defenses to negligence per se is undisputed evidence inconsistent with a finding of negligence, such as a heart attack while driving. You're unable to comply with a statute or any standard of care, really. Look at damages. You have compensatory damages. This is destruction of property or emotional distress. You have punitive damages. You look to malicious intent and ill will. Punitive damages are not available for ordinary negligence. An issue with the landlord, where the landlord repeatedly enters without notice and or permission, you may seek injunctive relief. Looking at the issue of battery, reasonableness of conduct is not relevant in battery. Reasonableness of conduct is only relevant in a negligence action. Intentional infliction of emotional distress, oddly, IIED may apply to the owner of a murdered cat. Self-defense, you must reasonably believe force is necessary, does not permit retaliation and or revenge, and you can only use force necessary to prevent further attacks, such as somebody punches you, you can punch back, or you can subdue the aggressor. Once you have them subdued, you can't continue to bludgeon them near to death. Look at nuisance. The interference in a nuisance must be substantial and unreasonable. Moving to the nuisance is irrelevant. You can still have a cause of action. Nuisance, in regards to nuisance, you are subject to the normal member of the community standard. So you have a heightened sensitivity, that's irrelevant. You're subject to the normal member of the community standard. Nuisance in compliance with government regulations is not a defense. I do believe that might mitigate damages, but it's not a defense. Violation of a criminal statute. This can be used to set a standard of care. Again, this is torts. But violation of a criminal statute can be used to set a standard of care in a negligence action if that criminal statute is meant to protect against the type of harm that occurred by specifying preventative steps that should be taken. In this example here is the sprinkler system that wasn't installed or operable, and fire damage occurred to the neighboring building. It was in a criminal statute. Looking at contributory negligence, this is an appropriate defense to negligence action where both parties seem to have been acting inappropriately. And the question here was in regards to them playing Russian roulette and shooting each other. Stupid. However, the majority would evaluate this now under comparative negligence. Looking at the zone of danger, there's a question about pedestrians in a crosswalk. One was hit, the other renders aid, then sues for IIED. The strongest argument in that situation was arguing the zone of danger, such as the second pedestrian was in direct physical threat from the driver's negligence, and they had fear for their own safety because they were in the crosswalk immediately behind the pedestrian that was hit. Rendering aid does not in itself insulate you from liability nor provide a cause of action, and that completes OPE review of torts.